All right, thank you and good afternoon for the Thursday meeting of the House Judiciary Committee. We have several things we're going to be reviewing. A continuation of House Bill 242 as far as public input and hearings. And we have three other bills that we also will be considering today. And I think what we'll do is take the bills first that we can. And since the public hearing will probably take most of the meeting time, we're going to hold that till the fourth bill, excuse me. As I mentioned yesterday when we started this, we're going to have just hearing as far as public comments, input yesterday and today. Once we complete the day, the public comments on House Bill 242 will end, and there will then be consideration probably next Tuesday of the bill solely by the committee. I'd like to recognize our distinguished jurist here today, the Honorable Lawton Stevens. Glad to have you with us again, sir. Anyone else here with the judiciary? Oh, gosh, yes. Our former member and now appellate judge, Mike Boggs, who was also co-chair of the committee and did an outstanding job. I think we got everyone covered on that. We got the juvenile court judge. I'm sorry, what was your name? Robin Shear, excuse me. Thank you, Judge Shear. Good to have you with us. We've got Mr. Hightower present with us. Come around, Mr. Hightower. We're on House Bill 175, which is a bill entitled An Act to Amend Article 3, Chapter 5 of Title 44 of the Official Code of Georgia relating to covenants and warranties. So as to provide that certain covenants run with the land as a matter of public policy of the state. We had a hearing on the bill. It went forward. There is a change that is desired to be made. The bill is back in our committee. Rather than going to subcommittee, we're going to have a full committee hearing on it at this point. Mr. Hightower, let me get your mic on and we'll hear from you.
Mr. Chairman, I greatly appreciate you letting me come before y'all again today. Just so everyone knows, we're on LC 295463S. If you'll look down on Section 2, what we have changed is where it says covenant. Now it says covenants recorded. I believe before it said covenants entered into, and we just want to make that language consistent with other sections. It really doesn't need to be covenants that are entered into. It needs to be shall apply to covenants recorded on that date. So that was the only change to, and Ms. Travis caught that through her due diligence and brought it to our attention and made that correction. But this bill passed out of full committee based, I believe, earlier this week, and that was the only change we're making.
All right. Any questions of Mr. Hightower by members of the committee? If not, that's fine. Thank you, sir. Do we have anyone else that wishes to address the committee on House Bill 175? If not, Chair will entertain a motion for reconsideration of House Bill 175. The move and second for reconsideration. House Bill 175. Further public input is concluded. It's now in the breast of the committee. Do we have any discussion on House Bill 175? If not, the Chair will entertain a motion at this time. The move to pass and second it. Any discussion on the motion? Are there any amendments? No amendments. We're having House Bill 175 as a substitute, committee substitute. Motion is to do pass. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, sir. Let's turn off all phones, please. Put all phones on vibration. Next we'll have is Mr. Atwood, House Bill 161. This is a bill relating to trial juries in general so as to change provisions relating to the oath of bailiffs.
Make sure my cell phone's turned off, Mr. Chairman.
Yes, sir.
That would not be good.
You might want to pull that mic down for us if you would, and we'll ask you to present to us, if you will, House Bill 161.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. This is frankly, a little cleanup bill. It's been requested by the judges, been working with the State Bar of Georgia as well as the Prosecuting Attorneys Council, and it's a modernization, if you will, of the oath that our bailiffs take. It has been modernized before, and simply what it does most prominently is change the word from the bailiffs would swear that they would keep the jury without meat or drink, water accepted, to the words that you see. Keep the jury as designated by the court, and you should not allow the jurors to receive any books, papers, nourishment, or hydration other than water, or to use any electronic communication device, which is very, very important to us. We don't want the jurors sitting there texting each other or reading newspapers or whatever while they're deliberating, except as approved by the court. Kind of an interesting piece of history. I did go back and look at, was this ever changed before? And it was changed where you would keep them without meat or mead. And I kind of like that a little bit, but and with that, Mr. Chairman, I'll yield for questions.
All right. Thank you, Mr. Atwood. Questions of the presenter? There are no questions. Who administers the oath?
I would assume it would be the Superior Court judge, or judge, I should say. That was one change we also had, Mr. Chairman. Originally, it said Superior Courts, and obviously more courts than Superior Courts have jury trials, so we also changed that.
I see. Any court?
Yes.
That's changed there. Okay. Any other questions of the presenter? This, I think, as you described it, the future of the free world may depend on our getting this bill passed.
Absolutely. Mr. Chairman, ladies and gentlemen of the committee, it does depend. Future of Georgia depends on this one bill.
All right. Thank you, sir.
Thank you, Mr. Chairman.
Anyone else wish to address the committee on House Bill 161? If not, we will suspend any further public input. The bill is now in the rest of the committee. Any discussion among committee members? There being none, the chair will entertain a motion. Motion is due pass by Mr. Jacobs. Has been seconded. Any discussion on the motion? Any amendments? There being none, the chair will call the main question, which is due pass of House Bill 161, and that is without any amendments. It's not a substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, sir. Okay. Where's I must have put my sheet up here. I guess I did. Somewhere. Lost it. Here, no. Yeah, here it is. All right. The next bill we have is House Bill 230 by Representative Powell. This relates to immunity for antitrust liability relating to hospital authorities, I believe it is, in Georgia. And Mr. Powell, I'll let you remain in your seat if you'd like to present from there.
Thank you, Mr. Chairman. Code Section 3665(1) and 2 provides that local governments, including cities and counties, are immune from antitrust liability to the same extent that the state of Georgia is. And this code section has been construed in various litigation to also include hospital authorities. Unfortunately, the Federal Trade Commission has taken the position that it really doesn't matter what the 11th Circuit says, that they do not think that because housing authorities are not specifically listed in the statute, that they are not instrumentalities of the state that are covered by this immunity. And so, in an overabundance of caution, we are adding hospital authorities to this code section to basically not create new law, but to give some credence to the established law as made by the courts of this state and in the federal system.
All right. You mentioned the 11th Circuit. What have they done historically dealing with the question about hospital authorities?
They have said that hospital authorities are local governmental entities that are covered by this grant of antitrust immunity. And I think the case is a case out of Valdosta. It was Crosby versus Hospital Authority of Valdosta and Lowndes County.
You say they are covered by the law dealing with
that they are
antitrust.
They are immune from antitrust.
Okay, hospital authorities are immune from antitrust, which means, in effect, there can be purchased by one hospital of another hospital and not the need to go through Justice Department for clearance.
That's correct.
Okay. Then what will your bill add to what the 11th Circuit's already
It
said?
does nothing to add to what the 11th Circuit. What it does is it prohibits the Federal Trade Commission from continuing to take the position that they've taken in the U.S. Supreme Court to try to overturn some of the prior 11th Circuit decisions.
Okay. And okay. All right. Thank you. We have several people who would like to speak of this too, but first of all, is any member of the committee wish to ask questions of the presenter? Yes, sir. Mr. Fleming?
Mr. Chairman, if I understand this correctly, this just puts it back the way it's always been and we
Yes,
always
sir.
thought it was, right?
That's correct.
Thank you.
All right. We have several people who want to speak, and I'll just go down the sheet for this. Is it I'm Victor Moldovan, excuse me. Yes, sir. Please come forward and take the seat by the mic and introduce yourself first to the committee.
Sure. I'm Victor Moldovan. I'm attorney with McGuire Woods. I am counsel to a number of various trade associations, including the Independent Doctors of Georgia. The bill by itself saying that hospital authorities have immunity as state government entities is correct. The problem and the concerns that I think that we have and other folks I've discussed it with have is that it creates an ambiguity that some of the private entities that lease hospital facilities from the authorities, those are a lot of the restructured hospitals, we call them, where not-for-profit entities are created. They lease the building, they lease the land, or they pay $1 a year, but they're actually private entities. They're not-for-profit private entities. The bill might be, and it's easy to fix, I think, and I'm not sure what the intent was, but the concern is that somehow if you're granting and saying, well, these hospital authorities have immunity, somehow that would transfer to the entities that actually lease the buildings and land from the authorities. I don't think that's the intent. If it is, correct me if I'm wrong. But if that was the intent, we need to clarify that that there should be an exception, that this provision should not apply to the entities that lease or purchase property from hospital authorities. For example, Northside Hospital is a restructured hospital. There's several others across the state as well. In fact, most of the hospitals that used to be hospital authority hospitals are now not-for-profit entities. Those entities are private entities that should be subject to the same antitrust rules as every other private entity, for profit or not for profit. And our concern is that this bill doesn't really address that, so we think that it would be easy to add language at the end saying this provision does not apply to entities that purchase or lease property from hospital authorities. And that, I think, would correct it. It would be clear then that it's just the government entity that has immunity, not the not-for-profit or for-profit entities that lease or buy the property from the hospital authority. Those are my comments.
I'm sorry. Go ahead.
That's our concern.
Are we looking at the fact that you have a lot of times? I'm thinking now maybe DeKalb, what used to be DeKalb General, DeKalb
Right.
Medical,
Right.
was a authority-operated hospital. Now it's operated by a private or a company, a public company, I'll call it.
Yeah, in fact, that's the concern, is that the hospital authorities have the authority to lease property or sell property under the statute, no problem. And the authorities themselves, I think, have immunity, and that's not the issue. But because they have the right to lease or sell the property, I think we want to be clear that the entity that is leasing the property, whether it's now a for-profit company that's now leasing it or purchased it or leased it for a long-term lease, they have like 40-year leases, that those entities are truly private entities at this point. And what we don't want to do is give them immunity and allow them to fix prices, get monopolies. That's bad for the consumers. It's bad for the folks who pay for insurance premiums. It's bad for the state under the Medicaid program because you're paying higher prices. So, the bill should be clarified, assuming you want to move forward with it, to say this does not apply to entities that lease or purchase property from hospital authorities.
All right. I believe, Mr. Jacobs, your light came on first. Questions?
Mr. Moldovan, I'm sure certainly there are entities that lease and operate facilities for county governments and for municipalities, and yet we don't have a special exception that applies to them in these code sections. I mean, how would the treatment be different as to hospital authorities from any entity that is leasing and operating a local government facility?
Sure. Today in Georgia, and back in the 50s, 60s, and 70s, and even 80s, a lot of the hospitals were hospital authority hospitals. So, you know, the rural counties, particularly Atlanta, Northside Hospital is a good example, DeKalb's a good example. Each county had this government hospital, basically. You could hire a management company and they would still manage it for the authority. But the problem is over the years now we've created these, and the code talks about restructured hospitals. It's under the hospital acquisitions law, it's under this hospital authorities law. They're called restructured hospitals. And what that is that the hospital authorities realized that they were restricted by being government entities. There are things that they couldn't do that they wanted to do. So they created this, what we're calling a restructured hospital, which is basically a not-for-profit corporation. It's a 501c3. And that entity is created basically to lease the land and the property and then operate as a private entity. So it doesn't have the restrictions of the government authority. You can go across county lines. It can do joint ventures. It does lots of things that a government entity can't do. So the concern is, and it seems to me, and the chatter seems to be, is that the concern is that this bill somehow would give that entity, those entities, immunity when they're clearly operating as, even if they're doing it they have a contract with the authority to provide free care and things that they do, lots of hospitals do. The fact is that they're private entities at this point, and what you don't want to do in a free market is give private entities, which are not, even if they're not for profit, the right to violate antitrust laws. It's incredibly important in today's day and age with the healthcare market the way it is, that we encourage competition, we encourage lower prices, and if we start granting these not-for-profit restructured hospitals the right to be immune from antitrust, what you're going to have is eventually monopolies, higher prices across the state of Georgia, which is the exact opposite of public policy.
Right. Well, I understand that, but I guess my point is that, if we can avoid adding language to the code, I mean, I think we ought to endeavor to do that. And my question really was, surely this same sort of thing happens elsewhere with regard to county governments and city governments, private entities leasing property and then operating. Okay, and I guess the question is, I mean, how is that treated under the current federal antitrust scheme? I would imagine that those entities are nevertheless held, to the standard of private enterprise.
And I think that, and so here's where to talk about the case a little bit that Representative Powell mentioned. The concern here is that what the 11th Circuit said and what the FTC is saying is that, and it's the Phoebe case, that's the case I think Representative Powell is talking about. The FTC is saying, look, you're a not-for-profit private company at this point. Phoebe says, oh no, we lease this property, we're a restructured hospital with the hospital authority in Dougherty County, therefore we get immunity. So I think that seems to be the dispute. So clearly the purpose of this bill, and Representative Powell can correct me if I'm wrong, I think the purpose of, you don't need this bill if you just want to say these authorities have immunity, private companies don't. You don't even need the bill at all. The provisions are clear. There's no doubt that a true hospital authority has immunity, no doubt about it. The issue is, and I'm sorry, I'm probably going into the weeds a little bit here, but the issue really is, if we don't need the bill, but if we're going to pass the bill to confirm that these authorities have immunity, which no one's disputing, the restructure of the private companies do not. So if you're going to pass the bill, you need to clarify that it does not extend to these not-for-profit entities that are clearly private. So that's why I think we don't need the bill at all. I think it would be perfectly fine. The law is perfectly clear that true authorities are immune. I don't think the FTC is arguing that. I think the argument is that are the restructured private companies immune? The answer is no, and I think that's what this bill is trying to address.
Oh. Mr. Powell.
Thank you, Mr. Chairman. I waived because I was going to point out the same thing regarding the state, local governments, that there are no exceptions for them, saying unless they lease it, unless they do this, unless they do that. Well, and I wanted to make the same point that Mr. Jacobs did.
I think the entities of hospital authority or authorities are in effect a government or a governmental sanctioned corporation, which is a little different from what you have with a municipality and maybe a county. We'll hear some more. I think some other people want to talk. Thank you,
Mr. Chairman.
Oh, you had a question. I'm sorry, one other question. Excuse me. Ms. Evans.
Thank you, Mr. Chairman. and not to belabor the point, but what is it about, if you look at line 19, this bill is expressly applying to hospital authorities created under this code section. So how would the entities you're concerned about falling into this, how would you say they would meet that beginning definition?
Sure. Under Article 4, Chapter 7, Title 31, the authority has the right, a specific power enumerated to lease property or sell property, leasing it up to 40 years. That's one of the enumerated powers. When you talk to people who are in support of this bill, and we understand where they're coming from, they're going to take the position that if you pass the bill as drafted, the not-for-profit restructured hospitals that lease the property are covered by this bill, that they're going to be immune. The only way to avoid that, which I don't think is certainly not the intent of the committee, and certainly that's not good public policy, I think the only way to avoid that is to add some language saying this section shall not, nothing in this section shall apply to an entity that leases or purchases property from a hospital authority. That way you're making it perfectly clear that it's just the authority that's immune, not people who, like me, if I go lease some property from the authority, I shouldn't be immune. I'm a private player. I think if you add that language, Representative, it's perfectly clear, no dispute down the road.
And if I could have a follow-up,
Yes,
Mr. Chairman, thank you. And perhaps we'll have to agree to disagree, but I don't understand. And if you could answer this specific question,
Sure.
This line says that it applies to hospital authorities created under this article. How would a company that leased from a hospital created under that article be considered an authority created under that article?
Right,
that doesn't make sense to me.
When I first read it, I had the same reaction. I thought, well, why do we need this? Because it's pretty clear that they're immune. And then I started thinking about it, and I started talking to other people. And the issue seems to be to fix this Phoebe case, where Phoebe is a not-for-profit entity, and the position that they will take, people who support the bill take, is that because the hospital authority has the right to grant these leases, and it's an enumerated power, that lease somehow is covered under this immunity penumbra or umbrella. And I agree. I mean, you don't need the bill at all, frankly. If all we're trying to say is that these guys are immune, no problem. You don't even need the bill. But I don't think that's what's going on. I think that they're trying to correct this issue where the FTC is saying, Phoebe, we think you're violating antitrust laws, and the way to fix that is to say, well, you know, they're leasing the property, they're a restructured hospital, and what this bill is going to be argued, I think, in court, and I could be wrong, I don't think so, is that somehow the state now, if you pass this bill, is, oh no, these restructured hospitals are immune, they can violate antitrust laws. That's the answer.
Thank you.
Thank you.
All right, sir. No further questions. Mr. Tommy Chambers, former member and chair of this committee, please come forward.
Thank you, Mr. Chairman.
I think you've heard the concern, and you represent Phoebe Putney Memorial Hospital, which is a state authority hospital.
Phoebe
Tell us
Putney
why we need this.
is actually one of these restructured hospitals that Mr. Moldovan was making reference to, Mr. Chairman. Let me say, first of all, that the premise of his argument is flawed because the FTC is not saying what he says they're saying. The FTC is not saying that Phoebe is trying to avoid antitrust responsibility. The law is clear. Phoebe Putney Memorial Hospital is a 501c3 entity, and it, like all other 501c3 entities, all private corporations, is in fact subject to antitrust enforcement. Is prohibited from engaging in anti-competitive practices, is subject to Justice Department or Federal Trade Commission intervention when they violate that. Sir?
The authority is, or
No,
the
sir,
operating?
The operating corporate entity, the 501c3. What the Federal Trade Commission is saying is not what he represented or believes it is saying. What it is saying is that there is no right, responsibility, or authority given to hospital authorities in this state by state law other than general corporate powers. Now, as we all sit here as lawyers, we think of an authority, be it in this instance a hospital authority that's been created pursuant to state law. 1940, this General Assembly passed the Hospital Authorities Law, and many hospitals were created all over the state pursuant to that. We have all believed that that was an entity. I believe the legislature believed it at that time, that it was creating a creature of the state. And whatever benefits are there for being a creature of the state, including United States Supreme Court endorsed and mandated exemption from Federal Trade Commission and antitrust enforcement, is there for the state, and it's there for the creatures of the state. What the Federal Trade Commission is saying is that there are no governmental type of authority or rights or powers granted to hospital authorities, but rather they have no more than general corporate powers. That's what's so alarming about what the Federal Trade Commission has now stepped forward and is saying. They're challenging what has been for decades considered to be the law. In doing this, they say that if you go down and, we can all pull out the Hospital Authorities Act and read the various powers there, what they are arguing is that there's nothing there that XYZ widget company doesn't have when they're created. Of course, that's a false argument. It's a revolutionary argument. It's an invalid argument. The Hospital Authorities Law grants to hospital authorities certain fairly broad powers, and as long as they are enacting what things they do within the constraints of those powers, they can do them as an entity of the state. They also make it clear that they can do no more than what they're specifically authorized to do under the Hospital Authorities Act. There's a case that came out of Tift County, Georgia. We had a mention of the Lowndes County case that went to the 11th Circuit, and the 11th Circuit said that the Hospital Authorities Act does provide for immunity from antitrust involvement. Well, the Tift County case had to do with a hospital authority that was trying to sell some kind of medical devices, and the Supreme Court of Georgia said they can't do that because it's not provided for.
Here's the bottom line. Hadn't heard from everybody yet. I'm sitting here as a chair dealing in an area that is not clear to me about what the law says. I heard Mr. Moldovan talk about, if you put a little language there, be sure that this restructuring of hospitals is not going to be included where you've got a private party now running the operation of that hospital, which is owned by the authority, and using that cover as a way of avoiding going through clearance for antitrust matters. Do you have a problem with the language he's talking about being added to it?
I haven't seen his language, but yes, sir, I do. There's, if Mr. Moldovan wants to do something.
Let me talk this way. Problem with the language. Do you have a problem with what I have just described as being a scenario that we want to try to avoid? So I'm saying, I don't know, I'm not picking on your hospital, but there's a number of hospitals throughout this state that I know are authority created that are now privately operated. I call it private, maybe a public corporation, Hospital Corporation of America, or others do it, where they operate those hospitals for the authority under a long-term lease. In fact, there's one right here down the street, Grady Hospital.
Yes.
Are we trying to give special coverage to those entities that are operating these hospitals under this change in the law? Yes.
Absolutely not.
How so?
Because it's the law now. I mean, Representative Powell's bill simply codifies what is existing law. If again, I would say
I say that's the part I have. We've got existing law. Where do we need it?
Because there's a challenge being made to that by the Federal Trade Commission, and this is to clarify that what the General Assembly did in 1940 and through subsequent enactments includes hospital authorities within the confines of immunity.
All right, sir. Thank you. I didn't mean to interrupt you, but I just wanted to get to what I felt was the meat of the issue here.
Well, I would suggest, Mr. Chairman, that if there's some desire to make clarifications of the sort he mentions, that ought to be something done in an independent piece of legislation addressing itself in the Hospital Authorities Law.
Well, we're doing that with what we have here. I suggest if we're going to do it, this bill may be where we do it, but I'm not sure. I'm not an expert in that area.
Let me mention one additional thing that is a part of existing law now, and that is there is the Hospital Acquisition Act that was adopted by the General Assembly about 12, 15 years ago that sets up a process whereby a hospital that is being acquired or leased under the kind of arrangement that's been described goes through public hearing process that is presided over by the Attorney General. The matters given full hearing and airing, and all these questions and things that he's mentioned are a part of that process that are being looked into by the Attorney General.
Now?
Yes, sir. It's existing law since 1998.
Okay. Any questions of Mr. Chambliss? Yes, sir.
Thank you, Mr. Chairman. What I'm trying to understand is that if it's, we already have the law, case law out there, and we have this law out there, what people are talking about with these hospital authorities. We're here to clarify. Why not go ahead and just make it extremely clear and clean up the whole thing? Because apparently right now it's not really that clear. We got two different points of views out there right now. I think we should try or attempt to try to clarify it all the way, and just wanted to get your thoughts. Why not just make the picture completely clear? What's the big issue with making it completely clear?
The distinction between what he brings to you and what I bring to you is that there has been a challenge to what I bring to you. Nobody has raised the issue that he brings to you. Nobody has suggested that private entities are entitled to antitrust immunity. That is clear. It's absolute. It's unchallenged. But the Federal Trade Commission has challenged what I'm here to talk to you about.
Okay.
Thank you,
further questions, Mr. Chambliss. Thank you very much
Mr. Chairman.
for coming in today. Next, we have Ethan James. Mr. James. Yes, sir.
Thank you, Mr. Chairman, members of the committee. I'm Ethan James. I represent the Georgia Hospital Association, and I will be briefed so as not to be redundant. I just endorse what Mr. Chambliss has offered, and also Chairman Powell's remarks. GHA counts among its membership all the hospital authorities as well as the restructured hospital authorities, and we agree that this does not change existing law. It just clarifies existing law, and we ask for your favorable consideration.
All right. Any questions of Mr. James? There are none. Thank you.
Thank you, sir.
Next, we have Josh Belafonte. Get your two mics on.
Yeah, Mr. Chairman, my name is Roy Robinson. I'm the registered agent for Hospital Corporation of America, HCA Hospital. Mr. Belafonte is our counsel here in the state. Since I'm the registered agent, I thought I should be here with him, but I'd like to cede my time to him.
Okay. Introduce yourself.
Good afternoon, Mr. Chairman. I'm Josh Belafonte. I'm with the Robbins Law Firm. It's an honor to be before my former boss and 3 law school classmates here today, in addition to someone who I served on a hospital board with. In looking at this law, I think that the committee's kind of heard the debate, Mr. Chairman. I think you've pointed it out. If there's a need for the bill, it begs the question of why are we restating what should be plain in existing law? And the answer is because it's not a restatement of plain and existing law. At a minimum, the FTC has alleged, and I was reading the complaint again in the back of the room, that the problem you've got here is you do have a public authority for which there's no question is a state entity in the hospital authority. But the question is whether those state authorities have been used as straw men for private companies to cleanse a transaction and then claim, as Phoebe has in this case, state action which would immunize the transaction from antitrust review. If that were not what they were seeking to do, we would not have a bill and we would not be having this discussion today. And so we would agree with Mr. Moldovan's comments and support his proposed amendment, again, without seeing the language but understanding it in concept. The other issues that have been brought is, I mean, essentially the question before the committee is, what is a private 501c3 operating arm of a hospital? Is it a government actor or not? And rather than looking at it in some of the contexts that have been provided, one easy way to do it is to look in just the metro Atlanta market. Northside Hospital is a hospital authority. If it wants to acquire a hospital and this bill were to pass and be interpreted as the proponents would like it to be, then that acquisition could be immune from antitrust review by claiming state immunity. If Piedmont Hospital, another nonprofit hospital, this is not an investor-owned and tax-exempt issue, but if Piedmont wanted to acquire a hospital It is not a public authority hospital. They're both nonprofit, but yet Piedmont would still have to go through the more rigorous review of that the FTC is putting the transaction involving HCA at Palmyra and Phoebe Putney through. And that's the distinction, and it begs the question, if you have two operating arms or two companies that are really doing the transaction, what makes the public authority one different or unique, as the FTC has said, or is it just a straw man for another type of transaction? One of the other safeguards that was raised is the Hospital Acquisition Act that was passed in '98 or so. The interesting thing about the Hospital Acquisition Act, there's several, but it's not going to address this. The purpose of the Hospital Acquisition Act is, does the community benefit survive the transaction? The most interesting part of that statute is that's exactly what the Attorney General is supposed to examine, is whether a community benefit survives. But community benefit is not defined. So we don't know what that is. So to claim that that act provides some type of safeguard, to me, seems to at least not satisfy the test they're offering to you. But again, I think as the committee has hit on, if the bill is needed, it is to change something in the law that the FTC is currently examining.
Well, tell me what you have as your understanding of when you talk about a restructured hospital authority.
Sure. And Grady is a great example just because it was recent and very public, and I was involved in that, so I can speak from firsthand knowledge. A hospital authority itself is limited in what it can do by law, and the courts have said what the General Assembly has set forth for hospital authorities is in fact their limit. One of the things they can do is lease their assets to a private nonprofit entity, and that private nonprofit entity does not have the restrictions imposed upon it that a pure hospital authority with members appointed by a county government do. And so in that sense, the distinction between a Northside hospital and a Piedmont hospital are not all that different. The key difference is Northside has a hospital authority board that meets, I can't tell you how frequently, but they meet and go through the business of what the 501c3 is doing. The question raised by the FTC is, in those meetings of the government actor, is it a straw man, is it a rubber stamp, in the words of the FTC, or is it actually something that is overseeing the operation of the hospital? And that's the question that's going on.
What governs that? An agreement between the authority and the operating arm?
Yes.
Is that what the FTC looks at?
Well, the FTC will, that is one thing they will look at, is the agreement itself and what is the role of the hospital authority and what is the role of the 501c3, and does the hospital authority really have any power to make decisions once those leases are entered into? They're, the lease of the assets are leased over for $1 or $10, and the operating arm has a good deal of autonomy to run the hospital itself.
Okay. Any questions of Mr. Belafonte by members of the committee? There's one, yes.
Thank you, Mr. Chairman. Josh, how are you, man?
Doing fine. Congratulations.
Good. We bring a little protocol. Josh was a 2L when I got to University of Georgia as a 1L, and remember him very well. Did an outstanding job. But you brought up some very good points and clarified the situation a little bit more. And so just so we're narrowing down and cleaning this up, and we just want to make it clear. So we're talking about antitrust liability, and on line 28, if you can look at line 28.
Yes, sir.
Where it says extent as enjoyed by the state of Georgia, and that such immunity shall extend, just so we clarify, and because we're talking about clarifying the issue at hand dealing with antitrust liability, to make sure immunity from antitrust liability is inserted in there, and want to get your thoughts there. So immunity, when you throw out immunity, judges and attorneys and everyone starts saying, okay, what are we talking about here? So I want to make sure that, we're talking directly on point, to the issue at hand, and we're talking about antitrust liability, and want to get your thoughts there about that type of language.
Thank you. I think you are, because in 27, when it has antitrust liability, I mean, that's what we're limited to talking about here. And really what as I read this provision to do is it is seeking to cleanse the transaction, because it's all actions taken by the hospital authority. And the way these transactions often happen is, and it's the one that has triggered this, the hospital authority will acquire, in many cases, the other hospital or the target of the acquisition. And then once that acquisition is done, it then transfers the assets to the 501c3 to operate it. So the question is the mere act of acquiring another hospital sufficient state action to bring it under existing hospital authority law, or, as the FTC has said, is it a straw man or a rubber stamp? But the issue specifically you asked, dealing with antitrust liability, yes, I would read that as the limit of this. This is not a tort reform bill or anything of that nature, if I understood the question.
All right. Got it?
Thank you.
Here we have, who's next? Somebody. Judge, thank you. Excuse me.
I don't have a question as such about the statements you made. What I'd like to know is, when this was before the subcommittee earlier, why wasn't you people here then bringing up all these various issues? It looks like you always have a right to speak, don't misunderstand me, but you're trying to get 2 bites out of the apple. You didn't like what happened in the subcommittee, so then you bring in more guns for this. Where were y'all this morning?
My name is Roy Robinson. I'm sorry, Judge. We could not get here for the subcommittee. I mean, it's just that simple.
Yes,
we could not get here for the subcommittee.
But that's the purpose of the subcommittee, isn't it?
Yeah.
That's from my mistake.
All right. Other questions? If not, thank you both for coming.
Thank you,
We're going to have next Monty Vasey of the Georgia Alliance.
Yes, Mr. Chairman, Monty Vasey, President, Georgia Alliance Community Hospitals. We come before you today on behalf of 85 not-for-profit hospitals across the state, many authority, many reorganized in support of the bill. And we hope that you would give it a favorable report. Thank you.
Well, don't jump up too quick. Any questions? I want to ask you this, Mr. Vasey. You've heard the conversation, and I'm really in a quandary here because I frankly do not see the use of our authority law protection being allowed to flow over to a private organization. I mean by private, it may be an organization that operates a hospital, but I have real concerns about what's being asked of this body of legislators to give that type of coverage, which, as I understand, would not flow with other operating hospitals. Mention the name Piedmont or Emory or that sort. Why are we doing this?
Well, we feel like it's already stated in the law under the Hospital Authorities Act, and the 11th Circuit
then why don't we leave it alone?
Has agreed with us.
Why don't we leave it alone?
Because of the Federal Trade Commission taking a narrow view of what the Hospital Authority Act says. They basically say that it just grants us general corporate powers.
Are they asking those questions only where you have restructured hospitals, or has there been time where they've asked that of pure authority-operated hospitals?
Well, where we have restructured hospitals and authority hospitals.
And what?
And authority hospitals.
Have there been authority?
The Federal Trade Commission has.
Well, I'm asking, has the Federal Trade Commission asked and inquired about the ability of a true authority-operated hospital being exempt from antitrust?
The one they've asked about is a restructured hospital.
That's my point.
Yes.
If it's
Mr. Chandler says a Lee County case out of Florida addresses this.
All right.
That the Federal Trade Commission there went after the authority.
Very good. Bill Clark, you want to speak?
Very briefly, Mr. Chairman.
All right, come state your concern or position.
Thank you, Mr. Chairman. Members of the committee, Bill Clark on behalf of the Georgia Trial Lawyers Association. I want to pick up on Representative Mabra's point. It is a bit of a belt and suspenders issue, but our folks aren't real big on immunities in general, but we can live with specific immunities. And so what we direct you to is on line 28, the phrase, and that such immunity shall extend to all actions of hospital authorities. One might be able to argue we aren't just talking about immunity from antitrust actions, but all actions. Just to be clear, though, to make sure that that's not the case, we would ask for an amendment to insert after the word immunity on line 28 the words from antitrust liability. And so, yes, it would mirror what's up in line 27, but we think it's a clarification that just avoids problems from unintended or avoids unintended consequences to the legislation before you.
Thank you, sir.
Thank you, Mr. Chairman.
That will close off those who have signed up. Anyone else wish to speak on House Bill 230 at this time? If not, the chair will close off further public input and allow promotions. Mr. Jacobs.
Mr. Chairman, in light of the testimony, I would like to make a motion to recommit the bill to subcommittee. In addition, I would implore the folks who came and testified today to be there, and furthermore to meet with the author and see if any common ground can be reached on the provisions of the bill. But at this time, I'd like to move that the bill be recommitted to subcommittee, and we will hold a hearing on it next week as quickly as possible.
We have a motion to recommit. Is there a second? Any seconds? Second. All right, there's been a motion to recommit with a second. Any discussion on the motion? The chair will call for the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. The bill is recommitted to the subcommittee. Is Mr. Powell's subcommittee? There was one. Yours. Okay. Jacobson. All right. Thank you, folks. Sorry it took longer than we anticipated with that, but I think we had a good discussion about it. Who is 28, Ms. Travis?
Mr. Lanier.
Mr. Lanier, okay. You might point that out about the question you had. We are back to where we were earlier with our continuing discussion regarding the Juvenile Justice Reform Bill. And as I had stated previously, we're only doing hearings today for those who wish to address the committee on the Juvenile Justice Bill. I have one, I believe two. Has anyone come in? Three people have come in. Is there anyone else who has not signed the sign-up sheet would like to speak to the committee today? If not, the first one we have is Carmen Allen. Carmen Allen, Ms. Allen. Thank you. Please identify yourself and who you represent, please.
My name is Carmen Allen, and I represent children in the state of Georgia who cannot get help through other agencies. I'm a volunteer advocate. I've been doing this for 12 years around the state of Georgia. I'm here, first of all, I want to thank everybody for being very nice to me and allowing me to have time to voice my concerns. I do want to say thank you to everybody who's worked on this bill. I am wholeheartedly for reform. I have worked with many children in the school-to-prison pipeline. I have one currently that I'm working with, and I've been doing it for many years. So I'm here because I'm concerned about some language in the bill. I'm concerned about the language that talks about evidence-based practices. I believe that that language is too broad. We are currently paying for evidence-based practices in the state of Georgia. It was codified in 1997 in the Individuals with Disabilities Education Act. These evidence-based practices have been used on the autism community for over 30 years. I am an autistic adult. I can only say that this therapy or this evidence-based practice has caused children in the state of Georgia to, and please bear with me, children are being harmed. Some children have committed suicide. And parents are not fully informed. They are signing to get therapy or evidence-based practices, and they're not aware that part of that may include restraint, seclusion, and it can in fact lead to a child being harmed. There have been kids that have gotten this very same evidence-based practices or therapies, whatever we want to call them, and they've ended up with PTSD, anxiety disorders. One in Hall County is an adult now, and he becomes violent. He cannot go to the public. One in Gwinnett County attempted suicide. One in Cobb County came home and started banging his head. Many times we refer to this as positive behavior supports because that's what's codified in 1997. And I actually had decided that I wasn't going to do this anymore and I wasn't going to come to the Capitol, but I was contacted by a mother in South Georgia. I live up north in Hall County. And this mother had been looking for help for a year and a half, couldn't find an agency to help her or a nonprofit to help her. Everyone was too scared to say something and be retaliated against. And her child was being restrained, secluded in an 8x8 room. This child was doing so bad that they took data for 10 days and he was having 90 incidences. He moved here from Kansas, where he originally had an autistic diagnosis and lost that diagnosis. And then he came here to the state of Georgia, and we put him in behavioral therapies, and now that child has his autistic diagnosis back. And he, well, yesterday I believe he was admitted into the hospital from gastrointestinal issues. He has so much anxiety. And what I'm trying to tell people is we need to, one, collect harm data. There's no harm data being collected. The Agency for Healthcare and Research Quality on April 7th, 2011 reviewed all these behavioral therapies, and even though they are evidence-based practices and therapies, they admit that they are low evidence, poor research, and that harm data should not be ignored. So I'm thinking that evidence-based practices, we may need to change that language, but we also need to collect harm data because we don't know the efficacy rate. You know, a lot of people say there's a 47% efficacy rate. Well, if you don't collect harm data, then that efficacy rate is not 47%. We have an institution, state-run institutions here in the state of Georgia, where we give these evidence-based practices and behavioral therapies. They're called the Georgia Network of Education and Therapeutic Services. We've had them since the 70s, and they have been serving behavioral issues or children with behavioral issues since the 70s. There was an audit done in 2010 by the state, and they're just dismal results. I think the average rate of graduation was less than 10% in a 5-year period. They can't even account for something like 90-something students. So if we want to see what these therapies may end up looking like, we can look at the GNETs, because that's where Jonathan King of Hall County hung himself. That is where Stefan Ferrari of Atlanta Public Schools was abused, and the Atlanta Public Schools fought, and it cost them $1.1 million, and they are now paying, or we are paying, in a settlement for services to that child into adulthood. That is the same place that Hunter, which is the young man that I am advocating for now, was also placed in restraint and seclusion. This is happening all over the state of Georgia, Cobb, everywhere, and I'm just scared that this bill may further codify and further harm children.
Let me respond, just because I did serve with the commission. I've been interested in our ways of treating the issues of juveniles, not autistic persons, but juveniles themselves who are, as I say, children in trouble or troubled children for some time. And what we've examined is what has been successful programs in other states as a measure of whether or not these meet what we think would be a good program for us to implement in Georgia. And that's what the meaning of evidence-based programs means, but it's not something that a bureaucrat sitting alone will make that decision. One of the things that we're doing under this legislation is we're continuing a program of a lay body of people who, I say not all lay, but people who work with the area of the state for juvenile delinquency problems in courts, and lay people who also are be involved in, to examine from time to time, for instance, the risk assessments that we use, and are those properly qualified to do what's asked by that document and that purpose. So I think there may be some things in what you described. I don't know the circumstances. Of course, if they've done something wrong, there's laws that they have to answer to for that. But I don't think we have the application within the meaning language of evidence-based practices that you're talking about with the question of autistic children.
It's not autistic children. I'm not only speaking for autistics. The children that are sent for behavioral therapy are all children, anyone with behavior therapies. I'm speaking because the autistic population has been subjected to this therapy for 30 years. So when we look at their numbers and their employment numbers, we realize that something is wrong. They're not employed. And I'll give you a perfect example. In this case, we used to call them seclusion rooms before we had a rule in the state of Georgia that was passed that said seclusion and restraints for all children. So now all children can be restrained and secluded within certain guidelines. This facility decided, or many facilities actually, they changed the rooms from seclusion rooms to sensory rooms, and now they're called opportunity rooms. And in this case, I spoke to the young man, and he was flipping out every time you said opportunity. And like I said to the school and the GNETs, which is a state-run facility, it's not a school, I told him, what do you think this child's going to do the next time when he graduates and he goes to a job interview and the employer says to him, I've got an opportunity for you? The kid's going to flip out. So I've worked with the court, and I'm just telling you that sometimes they're referred. I do know that the courts have gotten PBS training and that this is considered evidence-based. So if we leave that language, it's just so broad that it's going to allow experimenting with children. Right. ABA allows, and let me describe the therapy. The protocol allows that if a functional behavioral assessment does not work, a functional analysis is done. And what that is that they have the right to isolate your child, put them in a room, and purposely trigger misbehaviors over and over and over again for data collection purposes to establish function. No one can tell me that that kind of dehumanizing treatment won't end up in PTSD, anxiety disorders, and even attempted suicide. So my concern is that we put some kind of language, because if we give them $100,000 therapy that's evidence-based practice, but then we end up with anxiety, PTSD, and all sorts of other issues, we're going to pay for that too. So we don't have to just consider the $100,000 therapy that's evidence-based. We also have to consider the harm.
Thank you, ma'am.
Okay.
Any questions of Ms. Allen? No, we appreciate your being with us today and comments. Thank you. Judge Shearer, Robin Shearer, please. Come forward. Yes, ma'am. Good afternoon to you, and we'll have Mr. Johns with you. Pull your mic around, Mr. Johns. And
so I can see, do I need to introduce Mr. John?
I think he's well known to all of us. Mr. Eric Johns is the Executive Director of the Council of Juvenile Court Judges.
And my name is Robin Shearer, and I am Juvenile Court Judge in Athens, Clarke County, and I'm currently the President of the Council of Juvenile Court Judges. So thank you for this opportunity to be here and talk about this bill. You know, for a couple of years, the juvenile code rewrite has been winding its way through the legislative process in Georgia. And from the very beginning, there has been, I'm going to use the word that was just used quite frequently, best practices and evidence-based practices goal in that bill, and the judges have always supported that, and we continue to support that. We have had a lot of input and the opportunity to help fashion that as we've gone through the last couple of years looking at it. And so today, currently, there's total support from the Council of Juvenile Court Judges in terms of the best practices. I think now that at this point, our concern is implementation. We really are not sure how some of the proposed changes will be made, and with the idea that in Georgia, juvenile courts are pretty unique. They are not standardized, say, for instance, the way that superior courts are, with a certain allotment of staff, or there is a uniformity about superior courts and how they operate in the administrative function of judges. That's a little bit different in juvenile courts, so sometimes statewide implementation could hinge on that ability of juvenile courts to administratively execute changes, particularly when it might come to, for instance, applying for grants, reporting on grants. Our staffing at the office level is dependent on counties. So,
well, it's a good question. I think there's been a ongoing discussion about the issue of implementation through the commission into the drafting of the bill, and even with the work we're doing now. And I would suggest that what I've heard, just to pass on, I think our esteemed chair back here can add more to it, Judge Boggs, but what we are looking to do is taking what funds we will have initially appropriated, which is going to be about $6 million, I believe, and have that start as sort of a project funding for those areas in the state where we see the largest number of children are coming into the detention programs, lockup situations. Right. And because we find that those are happening because in those communities there are not available services now to meet the needs. Now, your area may not be the same, you may have some or not, I'm not sure, right. But I'd say in the Atlanta area, most of the metro areas, you do have programs being funded and provided by either the county and by the courts or volunteers or other organizations. So that it won't be a overnight change, but I think what you're going to see is a seeds planted and then the growth of it out from there as the practices become more accepted as a way to treat these children.
Well, I certainly think that's a logical way to do it, and I would only point out, in furthering that train of thought, is that another part of the variability of juvenile courts is that we have independent courts and we have what we call dependent courts, which right. depend on the Department of. I happen to be a dependent court,
yes, ma'am.
And I have a very good working relationship with the Department of Juvenile Justice. We collaborate. It's the nature of our community anyway, so we're really fortunate in Athens. And I think that we have been applying in Athens those goals of non-detention and saving detention for the people that we're afraid of, not the people that we're annoyed by. So I totally support that.
And you're right. There are the state, I call them the not independent, but the state or part of the program of juvenile justice, and you do have the independent courts, and we're concerned about that. We're not changing that, but we are going to mandate accountability as far as getting information from all the courts so we can have a better oversight of what's happening with children, whether it be in Clark County, Fulton County, or down in Taylor County, wherever it may be.
And
that's
I think
what we
the
need
council
that for. We need that information.
That data
really,
is important, and
that's
sharing
right.
data is important, and I completely support that and have for
I'm surprised
quite
we
a
waited
while.
all these years to do it.
That's right. So
really
we just look forward as a council to working in carrying out the implementation of this bill and having a seat at the table and answering any questions that you all might have. So thank you.
Thank you, Judge Shearer. Appreciate your service, too.
Thank you.
Your dedication. Any questions of Judge Shearer or Mr. Johns? No questions. Well, you've made a good presentation then.
Thank you very much.
Council. Thank you. I have one other, Wendell Phillips. I'm trying to see if he's in the room, maybe behind. There you are, over there. Excuse me. Come on up, Mr. Phillips. Keeping our name good, aren't you?
I am, and it's with great appreciation to you, Mr. Chairman, that I express the joy of being named Wendell, especially these Chairman Willard, members of the committee, all the familiar faces and some of the new faces since the last time I testified. Thank you very much for this opportunity to speak briefly, very briefly, today. I am the public policy advocate for the Presbytery of Greater Atlanta, which is a governing body of the Presbyterian Church USA. And I'm also a member of the board of directors of the Interfaith Children's Movement. Both of those organizations wish to express both appreciation to all those who have worked so hard for so many years on this reform measure. And we wanted to be on record as being in support, offering our unqualified support for House Bill 242. Hearing some of the testimony yesterday, I know especially from Melissa Carter, who is the executive director of the Barton Center, she referred to the number of members of the Just Georgia Coalition. So we would be among those who would be among the support system for this. It's been a real privilege to be close enough to the work of Voices for Georgia's Children, the Barton Center, Georgia Appleseed, and others who have worked on this for so many years.
Lots of good public interest groups.
Very, very much so. So we are honored, really, to be a part of that coalition. And also hearing Judge Teskey yesterday, Judge Boggs. I know Judge Teskey has been one of our speakers at our Presbyterian Day at the Capitol, speaking on juvenile justice issues. It was a pleasure to hear Judge Boggs yesterday as part of both he and Judge Teskey, of course, being part of the special counsel. Todd Markle, who is part of that, and we saw yesterday afternoon, has also been that. So we feel that this is we're happy to be part of this part of the process, which now begins to have all the earmarks of kind of sliding for home. And to you, Mr. Chairman, we appreciate the way you have received all of us in conversation, and sometimes with questions that may have seemed, to us may have seemed kind of dumb, and to you, you always took them seriously, and we appreciate the work that you have done in sponsoring this legislation.
Well, thank you. Appreciate you being here, Mr. Phillips. Any questions of Mr. Phillips? We'll put you down in favor of the bill then. Thank you.
Thanks.
I don't have anyone else signed up, but I want to call out one more time. If there's anyone who'd like to speak to the committee, this will be the time you have a chance to do it. If not, we're going to close all further public input, and I'll close by asking Judge Boggs, sorry, Your Honor. Judge Boggs, you've been very kind to be present. Do you want to make any concluding remarks? Nothing? All right. Well, thank you. Well, we will, as I say, be concluding the public input, and on Tuesday, the committee will then take up the bill with various proposed amendments and start looking to hopefully pass the bill on Tuesday. We'll start at 2 o'clock on Tuesday. If there's no further business to come before the committee, we will stand adjourned. Thank you.